Welcome, everyone. Welcome to Wolfson College's 2026 Seng Distinguished Lecture. It's brilliant to see so many people have turned out for this lecture. Absolutely wonderful to have so many of you in college. And I'm really, really delighted to welcome this year's speaker, Baroness Hale of Richmond. And I've been calling Baroness Hale of Richmond Lady Hale all afternoon. And then at one point, I received a reprimand. Can you please call me Brenda? So wherever I've written Lady Hale, I'm now going to say Brenda. Welcome to Wolfson, Brenda. It's lovely to have you. One of the perks of being a head of house is being able to meet amazing people, people who have actually changed the course of history for the better. And today it's an absolute treat because we have a really special person in our midst. Now, when I was sort of coming into college, someone asked me about Brenda. So I have to say this. If you have been looking up from your phones, you will know why Lady Hale is very, very famous. It's not for wearing these fantastic brooches at all. And today I can see you've got a beautiful brooch on. But it is for disciplining the holder of the highest office in our country when we all needed it most. That is what Brenda is famous for. Who can remember Prime Minister Boris Johnson? At some point, Prime Minister Boris Johnson decided to prorogue Parliament. I think it was in order to get Brexit done. But the good thing about this is that no evidence was found as to why this was necessary. Now, the first time I heard about proroguing Parliament, I don't know about you, but I had to look it up. I'd never heard that word before in my life. So I had to look up what prorogue meant. And now I do know, but I didn't know then. So when Boris Johnson decided to do this, many of us were very pleased when this was ruled unlawful. And it was ruled unlawful in a unanimous decision of the UK Supreme Court. And in the case of Miller versus the Prime Minister, the judgment was read out by Brenda Hale on the 19th of September 2019. Because Brenda Hale was at that point the president of the UK Supreme Court and the very first woman to hold that office. And as Brenda Hale read out this judgment, she had a lovely little spider brooch. And that spider brooch seemed to say, gotcha, to Boris. I'm really grateful that you were able to speak truth to power in this way. But I'm also really grateful that we live in a country where the executive and the judiciary are actually separate. And this separation actually works. And where speaking truth to power can mean that you tell the Prime Minister to sit on the naughty step, as you did that day. It's lovely to live in a country where the judiciary is not cowed, and that if things are not okay, then the executive is stopped without fear or favour. And what you did that day when you read out that judgment was really demonstrate with your colleagues that the rule of law was in rude health in our country. And those of us that were worried, because we hadn't heard about the parties at Downing Street at that time, but we suspected, those of us that were worried about whether those in high office were sufficiently adhering to the rule of law, we were gratified when this judgment was read out. So the Right Honourable Baroness Hale of Richmond began her career in academia and also worked as a barrister in Manchester. And there are a number of firsts associated with Brenda Hale. She was the first woman to be appointed to the Law Commission, became a High Court judge in 1994, an Appeal Court judge in 1999, and then became the first woman law lord in the House of Lords in 2004. So that's a number of firsts you've packed in to that career. It's amazing. And then in 2013, Lady Hale became the Deputy President of the Supreme Court. And in 2017, the first woman President of the Supreme Court. So, huge number of firsts. And since her retirement in 2020, Brenda hasn't stopped. She's been writing books. And I just spotted that someone has her book in the audience. I said to Brenda, how does it feel to see your book in the wild? I mean, I get super excited, but Brenda was like, well, you know, it happens. So the very first book has a fantastic title, Spider Woman, A Life. Fabulous title, published in 2021. And then With the Law on Our Side was published in 2025. And her newest book, Do We Have a Right to Die, was published this year. I'll stop speaking now and tell you that tonight's lecture is entitled Reflections of a Lady Law Lord. So I want you to put your hands together and give Brenda a warm Wolfson welcome.
Well, thank you very much. May I call you Ijola?
You can call me Ijola, yes.
Good. Thank you very much indeed. It is a real pleasure to be giving a lecture in honour of one great modern philanthropist in a college founded in honour of another great modern philanthropist. In fact, Sir Isaac Wolfson was the only person in modern times to have colleges named after him in both Oxford and Cambridge. Quite a thing. And there are memorable Lee Sang-ti memorials, not only in Oxford and Cambridge, but in many other places in the world. I was particularly intrigued to learn that his generous support for chess playing in China, as my late husband was a serious chess player in this country, and his son is still so. We don't celebrate philanthropy in this country as much as we should. Yet we can't do without it if freedom, scholarship, the arts and the sciences are to flourish. We cannot look to the state for everything. So thank you to philanthropy and the pineapple. Yep. But I want to talk today about something which we can only look to the state for, and that is the law and the justice system. In a lecture for justice in 2013, Lord Neuberger, my predecessor as President of the Supreme Court, said this, quote, "The media may concentrate on the government's health, social security and education programmes, but these are both secondary and rather recent functions of government. The defence of the realm and maintaining the rule of law at home are the two sole traditional duties of a government. Indeed, they are fundamental. If we are not free from invasion, or the rule of law breaks down, the social security, health and education become valueless, or at any rate, very severely devalued." End of quotation. It's worth remembering all of that. It's not well understood by either the politicians or the public today. I went into the law in 1963, so I'd like to tell you something about my life in the law and the justice system and reflect upon those things which have undoubtedly got better and those things which have undoubtedly got worse during the 63 years since then. The world which I entered in 1963 was undoubtedly a man's world. The women who entered it were expected to know the rules, many of them not written down. But I didn't know the rules, so was happily able to ignore them. I grew up in a small village in North Yorkshire, one of 3 daughters of schoolteacher parents. It was taken for granted that we would all go to university if we were bright enough, ignoring the rule that only 2.5% of girls went to university in those days. Not only that, if possible, it would be Oxford or Cambridge, ignoring the rule that the colleges were all still single-sex, and there were only 3 colleges for women in Cambridge and 21 for men. So a young woman had roughly 1/7 of the chance of getting in that a young man had. But I ignored that rule. And when I was applying for Oxford and Cambridge, my headmistress and I decided that I would apply to read law. My not being, in her view, well, I usually say clever enough to read history, but actually that's a bit of an exaggeration. What she said to me was, "Brenda, I don't think you're a natural historian. What else could we put you in for?" Anyway, we decided that I should apply to read law, once again ignoring the rule that women did not go into the law in those days, or only did so if their fathers were lawyers. And in 1960, when I started in the 6th form, only 2.3% of more than 19,000 practicing solicitors and 4.4% of nearly 2,000 practicing barristers were women. I don't think I knew that at the time, so again, I was ignoring the rules. But it turned out that the law was the right choice for me. I also learnt something from all those entitled young men that I met at Cambridge. Do they still exist? Don't know. But they took it for granted that they would easily go into top jobs in the city or make it at the bar. So, ignoring the rule that women did not go into university teaching, because there were no university teaching officers in the law faculty in this university until 1986, 20 years after I graduated. Is that not a shocking fact? No. Anyway, I ignored that rule, and I went off to teach law at Manchester University. And I chose Manchester instead of Bristol. Both of them offered me a job. Who chooses Manchester rather than Bristol? Well, it was the right thing to do, because they wanted me to qualify and practice as a barrister at the same time, which I did. Incidentally, I never was a barmaid. After the prorogation case, some lazy journalist read my Who's Who entry and misunderstood what practiced at the Manchester bar meant. That's the media for you, isn't it? Yes. But it wasn't possible to do both forever. Teaching the students got in the way of taking the longer and more difficult cases in court. Taking even the shorter and easiest cases in court got in the way of the research and writing which every university teacher must do. So I chose to give up the bar and concentrate on the university. There were at least 3 good reasons for this. My first husband had also started at the bar at the same time, and he loved it. I didn't love it quite as much as he did. We also thought it quite a good idea if one of us had a salary. University teachers are not paid a lot, but they are paid. And they get things like a pension and maternity leave. And we wanted a family. So a year after leaving the bar, along came my daughter, Julia. And that was a good idea because she now runs the London Stock Exchange. So obviously, after leaving the bar, I was never going to be any sort of judge. It would have been a foolish ambition anyway. The first full-time woman judge had only been appointed in 1962, just before I came up here, and promoted to the High Court in 1965, just before I graduated. But as an academic, you have to get your show on the road. You have to be a bit of an academic entrepreneur. Everything that I did led one way or another to a public appointment. So my first book was on mental health law, led to my first judicial appointment, presiding over mental health review tribunals, deciding whether psychiatric patients should continue to be detained in hospital. Helping to found the learned Journal of Social Welfare Law led to my appointment as the social welfare specialist on the Council on Tribunals, a quango which used to supervise and advise upon the myriad tribunals which mainly decided disputes between the citizen and the state. And this brought me to the attention of the Lord Chancellor's officials, and they offered me appointment as an assistant recorder, a part-time judge in the Crown and County Courts. And of course, I accepted that offer, ignoring the rule pushed upon me by my professors at the time that I should concentrate on my academic work if I wanted to become a professor, which of course I did. Fortunately, 3 universities within easy reach of Manchester turned down my applications to be a professor. I am so grateful to them. Eternally grateful. If I had been appointed to any one of those posts, I would never have had the career which I have had. So there's a moral in that somewhere. Then, co-writing a big book, The Family, Law and Society, Cases and Materials, led to my being invited to apply to become a law commissioner, one of 5 members of a quango which proposes reforms in the law. What could be more exciting than being the first woman to have the opportunity to propose reforms in the laws I cared most about and having a good chance that they would be implemented, as in fact most of my proposals were. And the Law Commission made me visible in high places, and eventually the Lord Chancellor offered me a job as a High Court judge. This time it was he who was ignoring the rules. Every other High Court judge had made their name as a very successful barrister. I had made my name, such as it was, as an academic and law reformer. But Lord Mackay of Clashfern was and is a brave man. He also appointed, it was very brave to appoint me, but it was even braver to appoint the first solicitor to be a High Court judge. And when I became a High Court judge in 1994, custom and practice had still not caught up with the fact that there were women High Court judges. When we went out of London on circuit, we were royally entertained as representatives of Her Majesty by the High Sheriffs. But at these dinners, the women were still expected to withdraw, leaving the men to their port and cigars. And this included the women judges. Of course, I went along with this, but I sulked. Very bad grace. And of course, we did the same when returning the hospitality in judges' lodgings. Eventually, I could stand it no longer. The junior of the North Eastern Circuit, and that's an important person, was a woman. And when the High Sheriff's wife withdrew, I told her that we were not going to go too. So we sat tight. I thought there was no harm done, or at least the only harm done was to me, for once more ignoring the rules. Many years later, the junior and I met after a talk which I had given in my hometown of Richmond in North Yorkshire, and she told me that I had put her in a really difficult position. She didn't want to offend me by insisting on going, but neither did she want to offend the male judges whom she might be appearing in front of the very next day. So ignoring the rules has its dangers, and not only for the rule breaker. Amoral. After 5.5 years, happy years on the High Court bench, I was promoted to become the second woman in the Court of Appeal. I've been the second woman as often as I've been the first. And I am eternally grateful to those first women who didn't either pull up the drawbridge or frighten the horses. I was the second woman in the Court of Appeal. I was the second full-time permanent member of the law faculty staff at the University of Manchester. I was the second woman in the chambers which I joined in Manchester. So there we go. After 4.5 happy years in the Court of Appeal, I was promoted to the Appellate Committee of the House of Lords, which was then the top court in the whole United Kingdom. I became the first, and sadly, the only woman Lord of Appeal in ordinary or law lord. Not everyone was delighted. Lord Hope of Craighead, one of the Scottish law lords, wrote in his diary for the 31st of December 2003, quote, "A new team of Brenda Hale, Bob Carswell and Simon Brown will inject a different atmosphere into the Law Lords corridor. Of the three, Simon will keep up the spirit of good humour. True. Bob will drop neatly into Brian Hutton's shoes as our man from Northern Ireland. True. And Brenda will be a source of some anxiety. Until we adjust to the very different contribution she will make." What was he thinking? Did I make a very different contribution? I don't really think so. The Law Lords were the final court of appeal from each of the three jurisdictions making up the United Kingdom: England and Wales, Scotland and Northern Ireland. With so much law applying throughout the United Kingdom, there has to be a final court to decide what it is in a way which binds the court in all three jurisdictions. So did I ever make a difference? Well, I want to give you two examples. One where I didn't but should have done, and one where I did. And forgive me, because we're lawyers and we don't mind talking about difficult things. Right. So early on, we had a case which really shocked me. A middle-aged man was convicted of having sex multiple times with a schoolgirl when she was aged between 13 and 15 and working for him at weekends. But because she had not disclosed this abuse until she was 17, the time limit for prosecuting him for unlawful sexual intercourse, what we now call statutory rape, had expired. So he couldn't be prosecuted for that, but he was prosecuted for the lesser offence of indecent assault, which of course this undoubtedly was. There was no doubt that he had done it. But he appealed to the highest court in the land on the ground that it was an abuse of process to prosecute him for the lesser offence when he couldn't be prosecuted for the more serious one. What do you think of that? Does it sound just to you? I won't take a vote, just in case you don't do it the way I want you to do it. Yeah. Yeah. Anyway, my four male colleagues agreed with this monstrous argument. I was outraged that such sophistry could overturn a just conviction. The only injustice, I thought, was done to his victim. Fortunately, the law has now changed, the time limit has gone, etc., etc. But I may have made a difference a few years later when a teenage boy was convicted of what is now called statutory rape against a 12-year-old girl. When the victim is under 13, it is no defence that the perpetrator thought that she was older. And he argued that such a strict approach was contrary to his human rights. I pointed out that every male has a choice about where he puts his penis. If he chooses to insert it into a child, he takes the risk that she may be under 13. Shockingly to some, but to the delight of later law students, I referred throughout to an alleged perpetrator as the possessor of the penis. The other law lords didn't put it in quite the same way, but they did agree in the result. So I think I may have made a slight difference there. But by the time I was appointed, in fact, the law lords were on their way out. In June 2003, the government had announced its intention to set up a new Supreme Court for the United Kingdom, which would take over the role and the judges from the House of Lords. Now, in principle, this was obviously right. Nowhere else in the world, as far as I know, is the top court in the land a committee of the upper house of the legislature. They do different jobs. Parliaments make laws and judges interpret and apply them. They're supposed to be independent of one another. Yet the law lords were full members of the House of Lords and could indeed take part in parliamentary business if they chose, and a few of them did so. The Supreme Court was set up by the Constitutional Reform Act in 2005, but we had to wait until 2009 for a suitable building to be found and converted for our use. Now, the building itself is perfectly situated on Parliament Square, with the Houses of Parliament opposite, the most important department of government, the Treasury, to our left, and Westminster Abbey representing God and the King to our right. So all the Constitution is ranged around the square. As the only woman law lord, I was, of course, put in charge of overseeing the conversion of the interior. Now, you might think that that was insulting, but actually I was really, really pleased because I happen to believe that the conversion has been a spectacular success, largely overseen by the wonderful Elsie Owusu, who was the architect in charge, but with a certain amount of encouragement from me, and blending the exuberant decoration of the building, which was opened in 1913, with some vibrant modern features. And I do encourage any of you who have not yet visited the Supreme Court of the United Kingdom to do so. It's well worth it. But our role remained exactly the same. We didn't acquire the power of almost all the other Supreme Courts in the world to overturn provisions in an act of the United Kingdom Parliament. But we were able to perform that same role free of the constraints of parliamentary procedure. Our proceedings could be live streamed or even televised. We could give judgments in our own way and explain them to the wider public in our own way, and be generally more open, transparent and welcoming than we had been in the Lords. There's even an excellent cafe in the lower ground floor which anyone can use. So if you ever feel you want a cup of coffee in Parliament Square, go into the Supreme Court and get one. They have good coffee. The food isn't so good, but the coffee is good. Yeah. So one of the things that has undoubtedly got better during my life in the law has been the creation of the Supreme Court, bringing clarity and constitutional propriety while keeping the fundamentals of the Constitution intact. Another thing which has undoubtedly got better during my life in the law is the diversity of the legal profession and the judiciary, beginning with gender diversity. By 1990, in England and Wales, women had gone up to 23% of solicitors and 17.5% of barristers. So that's in the 30 years since 1960. But there was still a glass ceiling, which made it hard for them to progress to the higher ranks. There had only ever been 5 women High Court judges, and all of them had been assigned to the family division, even though only one of them had actually practiced in family law as a barrister. Apparently, women couldn't be trusted to try serious crime, heavy commercial cases, and cases against the government in the Queen's Bench Division, or property, company, and commercial cases in the Chancery Division. But things did begin to change in the 1990s. The first woman was appointed to the Queen's Bench Division in 1992, and swiftly followed by 2 more. The first woman was appointed to the Chancery Division the following year. As it happens, I was the 10th woman High Court judge in 1994. So there were 6 of us amongst a total of nearly 100. And the men voted overwhelmingly that we should continue to be addressed as Mrs. Justice X, whether we liked it or not. They decided what we were to be called. But the pace of gender diversity didn't hot up much until this century, when many things did change. The powers that be realised that there were systemic problems holding women back. Many very able women were leaving self-employed private practice, whether as barristers or solicitors, because of domestic responsibilities or a desire for a better work-life balance. They were still not becoming Queen's Counsel as it then was, King's Counsel as it now is, the traditional recruiting ground for the High Court, or equity partners in large firms of solicitors. The Constitutional Reform Act 2005, which had set up the Supreme Court, also established the Judicial Appointments Commission. So the old system of a tap on the shoulder, which is what I benefited from in my appointments, was replaced with an independent and open appointment system based solely on merit. And so was the system for appointing King's Counsel. And the proportion of women appointed has increased dramatically. Women are still only 20.5% of King's Counsel, but this has been rising steadily over the past decade or so. Women are now 38% of the court's judiciary, and 52% of the tribunal's judiciary. So we're doing pretty well. Better though the figures undoubtedly are, women are still underrepresented in the High Court, Court of Appeal, and above all in the Supreme Court. Well, I've told you I was appointed to the equivalent of the Supreme Court in 2004. It took them 13 years to pluck up courage to appoint a second woman to join me. I did wonder what I was doing wrong, because I share Madeleine Albright's view that there's a special place in hell for women who don't help other women. I don't think I'd pulled up the drawbridge, but had I frightened the horses? Well, only you can be the judge of that. Yeah. But we went up to 2 in 2017, 3 in 2018, but by 2022, all 3 of us had retired, and they found only 1 woman to replace us, although fortunately they have found another woman to join her in 2024. And last year, we celebrated the appointment of the very first Lady Chief Justice of England and Wales. So we're doing not too badly on gender diversity. There is more work to be done, but we're not doing badly. But we are doing much less well on other dimensions of diversity. I was different from my fellow law lords in more ways than one. Not only a woman, but I had been state school educated throughout. I'd been an academic and public servant all my life, rather than a top barrister. A specialist in poor folks' law, family and welfare law, rather than rich folks' law, property and finance. And possibly most important of all, I had been employed rather than self-employed all my working life. So I was different from them in many important ways. But of course, I was just like them in 2 equally important ways. I was white, and I'd been to Oxbridge. We are doing better on those other aspects of diversity, but not so well as we're doing on gender diversity. On ethnic diversity, for example, the proportion of judges of South or East Asian heritage is roughly comparable with the proportion in the relevant age group of the working population. But the proportion of judges of Black African or African Caribbean heritage has scarcely gone up at all over the last 10 years. Only just over 1% of court judges and just under 2% of tribunal judges, which is shocking. The difference is that those in power now think that it's a problem. The formation of the UK Association of Black Judges last year was welcomed in the Supreme Court and by the Lady Chief Justice in a way which the formation of the UK Association of Women Judges was not welcomed in 2002. So this commitment to diversity is part of a wider commitment in the law to the values of equality, democracy, and human rights. That, as I put it in the case of Gaidan and Godin Mendoza, democracy values each person equally, even if the majority do not. So there are certain fundamental rights which everyone should have simply by virtue of being human, even if the majority would prefer that they did not. And again, for most of my professional lifetime, that understanding has been growing deeper and been translated into important legislation. The anti-discrimination legislation, which began in the 1970s and culminated in the Equality Act 2010. The acceptance in 1966 of the right of individuals to complain to the European Court of Human Rights that the United Kingdom had violated their rights under the European Convention, culminating in the Human Rights Act 1998, which converts those rights into rights in UK law enforceable in the UK courts. Among those rights is, of course, the right of access to justice. And during the first half of my professional life, this too seemed to be getting better. There was a growing recognition of the importance of access to justice for all. And that although access to justice is not the same as access to lawyers, in our adversarial system of judicial procedure, you are much more likely to achieve justice if you have access to legal advice, help, and representation. The Legal Aid and Advice Act 1949 was the final plank in the edifice of the welfare state created after the Second World War. And at first, it was developing and even expanding. But during the second half of my professional life, this is one of the things that has been getting worse. The legal aid scheme has been going backwards in eligibility, scope, and rewards for the lawyers who work in it. First, there's eligibility. When the Act was passed, around 80% of the population were eligible for civil legal aid. It's now down to 25%. If that was because rising incomes meant that more and more people were able to afford to employ lawyers, that would be a good thing. But in fact, the eligibility levels have gone way down in real terms, which is not such a good thing. Secondly, there is scope. The first legal representation scheme was quite narrow, limited to representation in the High Court, county courts, assizes and quarter sessions. That was where the bulk of serious legal disputes were decided. But then it was extended to criminal and family cases in the magistrates' courts. And then it was extended into mental health review tribunals because the liberty of the subject was at stake. And then they invented something called legal help, which brought the possibility of legal advice and assistance with the much wider range of problems which ordinary people experience these days, such as housing, benefits, and employment. So we could be proud that the scheme was no longer limited to those traditional disputes dealt with in the courts, but could also enable people to assert the new rights which the law had given them. Well, the first inroads into scope were made in the 1990s, with the removal of most personal injury claims and the introduction of conditional fee agreements, which have brought their own problems. But at least the idea was that those who couldn't afford it would still have access to lawyers. Then progress was brought to a shuddering halt by the Legal Aid, Sentencing and Punishment of Offenders Act, 2012, LASPO. That act took many important areas of legal work completely out of the scope of public funding, including most disputes between husband and wives, fathers and mothers. This means that some people with good cases will not pursue them in court, which is a denial of justice, but some people with good or bad cases will pursue them in person without a lawyer, which is time-consuming and inefficient. And the most difficult cases to judge are those where one party can afford legal representation and the other cannot. There is a weaker and poorer party and a richer and stronger party in most family cases. Denying the weaker and poorer party a level playing field is a denial of justice. Thirdly, there have also been severe cutbacks in the remuneration available for legal aid lawyers. I hear stories every day of very able practitioners who are having to leave publicly funded work because they cannot make ends meet. And some of these are the very diverse and socially mobile young lawyers whom we want to attract into the profession. But the combination of a high-cost education and a low-paid career is more and more of a deterrent. And this is all part of a wider problem, that the justice system has been starved of resources for many years. There are not enough courts, not enough sitting days, not enough lawyers, not enough staff, leading to longer and longer delays in all parts of the system, not only in the criminal justice system, but also in the civil, family and tribunal justice systems. Often the delays are worst where they should be least, such as cases involving children or sexual assaults. And why is this? Of course, the public finances are always under pressure. But why is the justice system not protected in the way that other parts of the public sector are protected? My suspicion is that the politicians do not care about it as much as they care about the health, education and welfare systems, because the public do not care about it as much as they do about the health, education and welfare systems. And that is because they do not know how important it is for everyone. But how can we get the message across without seeming self-serving? My recent book, which you were kind enough to mention, With the Law on Our Side, is an attempt to explain to general readers, ordinary, non-lawyer people, that the law and the justice system are there to do things for us as well as to us. Above all, that it is more than just the criminal justice system, which they can put in a not me box. You know, they hope they'll never be victims, know they'll never be perpetrators, and also hope they'll never have to serve on a jury. So the criminal justice system is crime fiction and TV courtroom dramas. Fun, but not for them, and indeed fictional. But we are all much more likely to need the civil, family, or tribunal justice systems, which are all doing things for us as well as to us. Whether we're injured in an accident, on the roads or at work, have problems with suppliers of goods and services, have problems with our employers or our landlords, or have tricky encounters with the tax and benefit systems, or experience the sadness and trauma of family breakdown in our own families or friendship circles. Very few people will have escaped all of those problems, and the law is there for them. So the book tells a series of stories. Part 1 tells the story of my visits to a wide variety of courts and tribunals. It was bookended by the Royal Courts of Justice and the Old Bailey, so, you know, the Rolls Royce at either end. But covering the grassroots of the Middlesbrough County Court, the Central London Family Court, the York City Magistrates Criminal and Family Courts, the London Employment and Benefits Tribunals, and the Inner London Crown Court. Random days. I did tell them I was coming. I thought it might be a little bit off-putting to see me at the back of the court scribbling away, making notes. But they were random days, nothing special, and they yielded many stories of hard-working judges and magistrates doing their best to dispense justice in some very challenging circumstances. And part 2 of the book tells the story of how the law protects the rights of everyone, including some of the more disadvantaged people in society: school children, disabled people, LGBTQ+ people, women, workers, patients. It relates the facts of real cases, raising real dilemmas for the law, and then it asks the readers what they think the answer should be. Gives them a bit of a hint as to how they should start thinking it through, and then tells them what the court thought the answer was. At a literary festival that I attended not so very long ago, the compere said, well, he'd gone through all of this exam paper and he got all the answers wrong. But that wasn't the point. It's to try and get across that these are difficult questions, balancing, for example, the rights of a disabled wheelchair user with the rights of a mother with a baby in a buggy on a bus. Well, it's fairly clear whose rights prevail, but what do you do about it? What's the practical consequence of that? It's all that sort of everyday thing. And part 3 tells the story of how law is made. The judge made law in the courts, and it takes 3 important decisions of the Supreme Court. The rules and regulations made by government under powers granted to them by Parliament, and the acts made by Parliament. And this last chapter demonstrates that Parliament is indeed sovereign. It can make or unmake any law, even though I hope it demonstrates that there are some laws which it really shouldn't make, but there's nothing we can do to stop them. Which brings me to perhaps the most important thing, which has been getting worse recently, which is the respect amongst press and politicians for the independence of the judiciary and the rule of law, the other pillars of our Constitution. Of course, as the Attorney General has recently been saying, unjustified attacks on the motives of judges, such as the infamous Enemies of the People headline in the Daily Mail, are also an attack on the rule of law. If you undermine people's trust in the judiciary, you risk undermining the ordinary instinct of most people to obey the law. If you're not going to get a fair trial, why bother? There was another egregious example recently when a Court of Appeal judge was accused of bias because of his previous links with the Fabian Society, the Labour Party, and the Society of Labour Lawyers, when he, along with 2 other judges, set aside the interim injunction preventing the Bell Hotel in Epping being used to house asylum seekers. Somehow, lefty lawyers are suspect, whereas righty lawyers are not. There's no such thing as a righty lawyer, isn't it? Let's think of another way in which we can alliterate it. Well, tabloid newspapers are one thing. We have sometimes to tolerate what they say. But senior politicians ought to know better. As Shabana Mahmood, while she was still Lord Chancellor, said when giving evidence to the House of Lords Constitution Committee last year. She was referring to the then Shadow Lord Chancellor, Robert Jenrick, and the Shadow Home Secretary, Chris Philp. It is, as she said, one thing to criticise judicial decisions. Now, that's fair enough. We can be criticised. But another thing entirely to call in question the motives of the judges. Undermining confidence in the judiciary undermines the rule of law, she said. But it's not only the current opposition. In June 2022, an all-party parliamentary group on democracy and the Constitution published the results of their inquiry into the impact of the actions and rhetoric of the executive since 2016 on the constitutional role of the judiciary. And they quoted Lord MacDonald, a former director of public prosecutions, who believed that a vogue for ministerial attacks on judicial decisions began in the late 1990s and early 2000s. This seemed to be part of New Labour's attempt to present itself as tough on crime, but it had paved the way for a more egregious ministerial attitude since. In the group's view, they had evolved from critique to attack, with 4 characteristics: misrepresenting decisions or the reasons for them, suggesting that judges are biased, making threats against the judges, and conflating cases with political consequences with the courts determining political questions. And the group were particularly worried that some of these attacks had come from the members of the government who are charged with upholding the rule of law and the independence of the judiciary. In 2016, for example, Dominic Raab, then a junior minister in the Ministry of Justice, described the decision of the High Court in the first case about Brexit, brought by Mrs. Miller, as an unholy alliance of die-hard Remain campaigners, a fund manager, that seemed to be an insult, by the way, and an unelected judiciary, which had thwarted the wishes of the British people. It had, of course, done no such thing. It had upheld the constitutional principle that while government can make or unmake treaties, only Parliament can change the law. Sir Jonathan Jones, who was head of the government legal service, said there's a difference between law ministers attacking judges and ordinary ministers doing so. Historically, the law ministers have kept out of public debates, save for when it became necessary publicly to defend judges. Now they are leading the criticism. That is not the case currently under the present government. But even they are planning to take immigration and asylum appeals out of the hands of independent judges and into some less independent way of handling them. And the advances in equality and human rights protection are under threat from the opposition parties of the right. Yet, as I tried to show in With the Law on Our Side, we all need that protection, and life will be immensely more dangerous for everyone if it is withdrawn. I believe that the philanthropists whom we are remembering today would have understood that. They made a lot of money. You can't make a lot of money without a functioning justice system to support the commercial world. You can't have a functioning justice system without the rule of law, access to justice, and an independent judiciary. Thank you.